Very well said.
Well, I was ready for you to be much more succinct.
That's a fact, Jack.
Blown up, sir.
You're listening to the Help Me with HIPAA podcast, where HIPAA and humor collide to make learning fun. Your delightful hosts are Donna Grindle and David Sims. Relax. HIPAA help is on the way.
Welcome to episode 3, 2, 1 of the Help Me with HIPAA podcast. Yes, 321. Wow.
Yeah, I know. It's like one of those things where it's just a habit that you can't break to keep showing up and talk to each other on a Friday.
Is that what it is?
Yeah.
I'm one of your bad habits.
Oh, yeah. Yeah, you're way up there at the top.
That's why Carla's always going, what are y'all laughing about down there?
Mm-hmm. Yeah. Are you done yet? That's what they both say on both ends of the house. Are you done yet? No, we're still talking.
That's enough of all that giggling going on.
Nah.
Oh,
it's a
man.
sleepover.
I know. Yeah, we've had those.
Yeah.
So,
right.
I always kid with people. I'm like, Donna's is the only place my wife will let me go have a sleepover with other women.
She's like, yeah, just go. Yeah.
Oh, boy. So today we're going to be talking about 7 HIPAA facts.
It's just, there's so many reasons that we need to do this. So we're doing it.
Yeah. Well, we're starting to see some of the trains go off the tracks in different ways. And so hopefully this is our way of correcting the universe.
Or at least, having one thing to reply to people when they ask us.
No. Yeah. We're recording this so we can say, go listen to this.
Yeah. Refer to number 4.
Yeah, I know. So we're going to cover some of these facts, and we've done before like the HIPAA myths and things like that. So we're just like, look, we're just going to cut to the facts, or as Donna would like to say, it's just the facts, Jack.
That's a fact, Jack.
Yeah, that's right. Shout out to the Stripes movie. What was it? 80 something. 1980 something. I don't know.
Yeah, you watch it, it was a long time ago.
Yeah, it's back when movies were awesome. But anyway, make sure that you subscribe to the podcast and leave a rating. We actually haven't had any ratings in a while. Reviews, rather. Haven't had any reviews in a while because we haven't asked for them. So you don't get if you don't ask. So we're asking for reviews. And
subscribe, review, all that kind of stuff.
Yeah. People doing their job, sharing it out. We're definitely seeing a lot of people sharing it out and a lot more engagement in the podcast and things like that. So thanks.
Keep up the good work.
Absolutely.
Yeah.
And as always, thanks to our donors. We definitely appreciate it. Love it. So anyway, I guess we should say that our HIPAA
say what
is going to be the entire episode yet again. Because it's just full of just craziness. Full of craziness. But we won't belabor the point, and we do want to open up to say CISA, our friends over there. We mentioned a few weeks ago that they come out with a new bad practices website. So I guess if you can't tell people all the good things to do, then tell them the bad things to stay away from.
Yeah, if you're doing this is wrong. Don't do that.
So they added one because they said they would be adding them from time to time.
Mm-hmm.
And so they have one. So let's talk about that for a second.
Well, it's pretty straightforward. It is a bad idea for using just single factor, meaning just a password for remote or administrative access.
Mm-hmm.
Just wrong in so many ways because, well, you're just basically leaving the door open because there's a list of password cracking tools that go through so many things and they're so fast now. Without that 2-factor, it doesn't take them long.
Mm-mm.
Mm-mm. Mm-mm.
Not at all. So,
No.
And it's, I guess we need to to talk about the elephant in the room. It is inconvenient to have yet another factor of authentication, but security is not convenient.
Rule number 1.
Yeah. Rule number 1. Security is not convenient. It's not convenient for me to come to my house and pull my key out, unlock the door, which actually I don't even do that anymore. I have a PIN code to unlock the door, but that's not even convenient.
No, it's not. Yeah.
Yeah. And then I have to turn the deadbolt after I put the code in. That's terrible. Terribly inconvenient for me to have
when
to
my
do
hands
that.
are full.
I know.
And I'm in a hurry.
Somebody's like, get the one that automatically turns the deadbolt.
Yeah. Yeah. Well, that's what I have. But
Yeah.
again, we're
I'm not
those
able to do
nerds.
that. For some reason, the seal on my door is too much. So, like, because when I unlatch the deadbolt, the door like pushes open just a tad. It's like it's too tight of a seal.
I'm not touching that one. So let's.
It's too much.
You're
too
too
much weather
tightly
stripping.
wound.
Too much
packed
weather
in.
stripping. Yeah, I
Yeah.
know.
We
All right,
just
so-
talked about this, David.
I know. I'm getting there. All right, we're going to dive into just fact, Jack. Number 1. HIPAA does not apply to everyone. I know, it's shocking.
No, it does not.
It does not apply to everyone.
It's a very specific set of organizations that it applies to, and only those organizations.
Yeah,
You can't even say it applies to everybody that provides medical care because it doesn't.
that's true. Yeah. And kind of to piggyback off of it, not all health information is protected by HIPAA.
Again, that's right. So you'd be hard pressed to find a very general HIPAA statement that the average individual would be able to make, other than when I go to the doctor's office and I share information and they file an insurance claim, then everything that they have about me is protected.
Mm-hmm.
If I go to the hospital and they file an insurance claim, then everything they have about me is protected. But technically, if you go to a place that's concierge medicine, so all they do is take cash, HIPAA doesn't apply.
No.
Or
But
care credit.
HIPAA might.
Don't even start with it. Don't even start. Oh, God. You know, there is no such thing as a HIPAA that is signed into law. It was a bill years ago.
Yeah, I was kind of shocked you didn't actually have that on here, but I guess because we talked about it so much lately, there was no need to bring it again.
There's no need. Well, you know, it's just rampant. So the bottom line, though, is you have to be a provider of care that charges money, and to get that payment, you transmit an electronic claim to a payer of insurance. Then you, the provider of care, and the entire track of that payment to the insurance provider, and they're providing health insurance, not just some insurance. So if it's car insurance that's paying for it, that's not health insurance paying for it. So there is the chain of evidence, if you will.
Mhm.
Chain of evidence.
There you go. I like it.
Yeah. So anything from the insurance company, the clearinghouses that help exchange that data between the two, and the healthcare providers. There you have it.
And we won't get into the business associates.
Well, yeah, that only creates more confusion. But the only thing that is protected is very specific information that you share within that transaction that takes place.
Mm-hmm.
So if you could find a doctor who only files paper claims today, that doctor could still make the argument that they're not covered under HIPAA. So no, it is not obvious who is.
That is true.
So it's harder to define who is covered than who isn't. So just
That's
assume
fact,
they
Jack.
aren't. That's a fact, Jack. Just assume they are not covered unless you can prove they are. is almost how different it is.
Yeah.
So,
All right. This brings us to fact number 2. HIPAA does not limit when a patient can choose or what a patient can choose to do with their own information.
no,
So
it's all about giving you the right to choose who you share things with and what you share. And based on the stuff people put out on social media, there's a lot of oversharing. Look at my toe. What's on this?
oh no, I violated HIPAA against myself.
There is no such thing as self HIPAA violation.
Not yet.
It only limits what those people, reference number 1 we just covered, what information and only some of the information that is in that chain of evidence and what's happening in that.
Have you seen that though? Like, have you seen somebody telling a person that they violated HIPAA by talking about their own medical stuff? You have?
Yeah, I can't tell you that. I would be violating HIPAA.
About your own stuff.
Yeah.
Yeah.
Yeah. You can't ask me that. We see, okay, well, it doesn't apply to them. And, oh, well, you can ask me, but I can't tell you because that violates HIPAA. It is just wrong. That is not the way it works. Okay? It's not the way it works. The way it works is you get to decide and you are authorizing that chain of evidence that we just talked about to only do the things they need to treat you, get the payment, and keep the business up and running. That's it.
So don't let my wife listen to this episode because then I can no longer say, I can't tell you where I've been because of HIPAA.
Yeah, like she'd even play that game with you.
I know. Yeah. You're not going to get that one on me.
Yeah.
Oh, so number 3, training is one of those things I always just have to hammer home. So number 3, the fact, the training that most people receive for the annual HIPAA training. Notice I said annual HIPAA training. It's not everything there is to know about HIPAA.
No, there's not.
And this causes confusion because so many people take the 30-minute course and they take the test and they're like, I'm an expert in HIPAA. I made 100.
And I did it 12 years straight.
I know.
No. You're getting what you need to know to do your job.
And it's the absolute bare minimum.
Yeah. So all of I've worked in healthcare for years, so I really do. I've been to tons of HIPAA training, and that tells you what you need to do your job. And some of that isn't even right, but we'll get to that in a minute.
Yeah.
That, I've seen a wide variety of, apparently there's a fly. I've seen a wide variety of theories that this training is enough. You know what I'm saying? And
enough for what?
Yeah, it's even enough for them to do their jobs, and often it's not.
Well, what's scary to me is that when you talk to people and they say, I'm the privacy officer, I'm the security officer, I'm the compliance officer. Okay, what additional training are you getting? And they're like, what? I'm like, you should be getting a ton more training than everybody else.
Yeah. That's explaining how you actually manage this stuff.
Yeah.
I mean, my whole company's built around all the things that you have to do to properly manage this stuff.
Mm-hmm.
And you think that you can sit in on a 30-minute, 45-minute video course, even some of those where it's 2 or 3 videos. No, we could give you a very basic overview in about 2 hours, 3 hours worth of video.
Yeah.
And
I was going to say,
very basic.
Our introduction to HIPAA course that we did a few years ago was
2 hours and 45 minutes.
Yeah, I was going to say it was close to 3 hours, and that was just a basic introduction.
Yeah.
To HIPAA.
And it is for folks that, if you take that, you learn all the pieces in a very basic way.
Mm-hmm.
So if you've taken that, you don't even know anything. You know how I had a mentor that always used to tell when you bring in those interns or you bring in those right out of college, raring to go,
Mm-hmm.
who would say, all right, let's get this clear. You have now entered the rat race. All college gave you were shoes. You now have to actually learn the route of the race and learn to pace yourself and get yourself in shape so that you know where even the rest stops are. Because you never stop running from here on. Off you go now.
Yeah.
It's giving you not even some good shoes in that 3-hour training course.
Mm-hmm. Yeah, it's it's the equivalent of the Cliff Notes version of Gone with the Wind. It's like
Yeah.
you can read about it or watch something that's an overview, but it's so far from what you really need to know.
Mm-hmm. And it's like this is what it's like, because I don't know if you got it. There's a ton of these services now that'll give you professional books in very condensed format for you to read or you can listen to, right? So
Yep.
Read It For Me, Blinkist, there's another big one. So they're cool.
Yeah.
But it gives you a taste of what is in that book.
Mm-hmm.
If you found that summary helpful, you should go read the book.
Yeah. Well, herein lies the problem, is that people aren't typically going to read the law.
Mm-hmm.
And this is where we have an issue. And we can talk about this now, or we can talk about this on number 6. But
yeah, well, we can talk about it in both places.
Yeah. But, the thing that drives me crazy is that people will refer to something they've Googled and not referring to the actual law, because oftentimes what they find in the Googling, it can be inaccurate. It can be opinions. It can be somebody saying, this is how I interpret it. And in some cases, I'm looking at it going, how can you possibly get that interpretation out of it?
Or it could be something about a very narrow, specific scenario that this answer would only apply in that very narrow, specific scenario.
Yeah.
And if you knew what all that meant, you would know that's what they're saying.
Yeah. I'll give you some type of example here where I had a conversation with an MSP recently, and they're making the point that they don't believe you should have to notify HHS if there is a breach under 500 records. And they reference an HHS page, which basically gives some guidance on notification. And the way the page reads is it's implied that you notify under 500, but it doesn't specifically say notify under 500. But if you read it, it's there without being there.
Mm-hmm.
But the point that I made to him is, let's go back to the law. The law absolutely specifies what to do under 500, and it says to notify. Here it is in the law. Let's not reference some webpage, even from HHS. Let's go back to the actual law first and then move forward from there.
Yes, because HHS is a single document, again, is generally about a very specific answer.
Mm-hmm.
Here's the question, here's the answer. And a lot of those that people reference there, it's like, okay, well, they're answering that question. Right. Not how does the breach notification law work? It was it was probably the one that tells you how to report breaches over 500 time frames.
Mm-hmm. Yeah.
So
So-
that was probably the answer.
Right. And this plays into why people say HIPAA's confusing, and it'll say one thing over here and something completely different over here. It's usually not. It's because you have people that have misinterpreted it and then presented it that way.
Yeah. Or they're giving you just a very tiny sentence in a huge paragraph.
Yeah,
And you
taken
need
out
the
of
whole
context.
paragraph, kind of thing. Well, I was
Yep.
trying to be more visual, but yeah, it's out of context, David.
Let's get to the point.
But most of the training cannot cover the law. You just, it's not going to happen. I've even seen cases where they our people are fully educated, and then you get it and they have literally 3 questions on a quiz that they make them answer every year.
Mm-hmm.
And if you and a lot of people got one of those wrong. So, it that does not make you a well-versed HIPAA person. And to make that assumption that you know everything you need to know, I don't know everything I need to know. I'm constantly looking things up and talking with other people that do what we do on the actual, here's what the law says. Now here's this scenario. How does it apply?
Mm-hmm. And this is what you do day in and day out.
Yeah.
So imagine if it's a portion of your job and you're
Yeah.
not doing this day in and day out.
Well,
So
it's not even part of your job to understand anything other than how it applies to your job.
mm-hmm.
You don't need to understand all the other stuff. That's why we say if it's not in the training that we do, it's 5 definitions, 5 rules, 5 scenarios kind of approach.
Mm-hmm.
But one of the rules is if it's not covered specifically in this training, you need to ask. Because you need to ask someone that knows specifically what to do, and it goes up the chain. If your supervisor hasn't gotten any more training than you have, then you need to go to the privacy officer, and the privacy officer, as you previously mentioned, should have more training than everybody else on how it actually works, and not just a little bit. And by the way, a HEMA certification, any of those things, again, those are point in time. If you don't maintain and continue to get educated on how this stuff is applied and how things happen, then it's not very helpful. It's not a no-brainer kind of job.
No, not at all.
No. That you learned that when you first came to me and you said, I've come to the mountaintop to learn about HIPAA.
She handed me a paintbrush. Showed me a fence.
That's right. But it is the, one of the first things that we try to teach people is, it's vast.
Mm-hmm.
But most people don't need to know all of it. So
You must first catch this fly with the chopsticks.
that's right.
Yeah.
Yeah.
So-
After you learned how to spell it.
Yeah. Very true.
So if you have someone on your staff that you have appointed a privacy or security officer, you need to make sure they get training. And if you are the privacy and security officer and you've never gone, you don't know how to go read the law, you need to learn how to do that. I mean, there's a reason that we teach that in our basic HIPAA. I mean, it's the prereq course to come into the boot camp now. Because we have so much to cover. We can't cram it all into 3 days. We've actually had to add a prerequisite course and quiz. So, and it kind of freaks people out, but that's okay.
We just need to have HIPAA week.
That's right. Yeah, you never know. You never know. But the big thing to know is no one knows it all, but a lot of people know a lot of it, but it's because they spend a lot of time, like us, reading the law, reading the guidance, reading the OCR settlements. That'd be one. Anybody that's being that, expert on it, how many of the OCR settlements have you read? Like the agreements, not the press release, but actually read the agreements. That's probably a really good, I don't know, a measure.
Yeah.
To say, because I think I've read all of them. So be curious. That would be a knowledge piece.
That's a good due diligence question for you.
Yeah, let's just start with that. How many OCR settlement resolution agreements have you read? And then wait.
Right. And then wait. All right, that brings us to number 4. And I think people are shocked by this one, but very few organizations have ever paid the scary HIPAA fines.
I know. No, I've had to provide the stats to people before. I'm like, here it is. I keep a spreadsheet that I use to pull charts from for presentations because, I do a lot of them. And, I just, every time there's a resolution agreement, I go add it to my list. And I have them going back to like 2012. And I add it to the list and update the charts. Boom. We haven't even had 100 yet. Not even 100 in all these years. Not 100 people have paid, even been a resolution agreement.
Yep.
So I think we're up to 90 something. And the vast majority of those have happened in the last, I'd say since 2016. I'd have to go look to know exactly. But even then, what was it? A big year was 30 organizations in a year.
Mm-hmm.
I don't know that we crossed 30. We got close, but one time. And they'd have to go to town to get anywhere close to a large number this year. So what do you think about the fearmonger people who talk about how scary the cases are?
Well, what gets me is people they'll run around and they'll talk about the fear of the scary fines or the fear of the audits or whatever. And I'm like, you are much more likely to have a terrible ransomware attack, and yet you're not concerned about that.
Yeah, exactly.
I mean, you are much more likely to get hit by ransomware.
And our job is risk management, right? So statistical likelihood, what would be the likelihood of any specific organization having to pay a fine or enter into a resolution agreement with OCR? Statistical likelihood, there's what?
Yeah, we're talking less than 1% probably.
Yeah, 0.0 whatever percent. I don't even know what that would be because I think there's like, 1 million or more. At one point I saw they think there's 3 million business associates.
Yeah.
And close to 1 million different healthcare entities.
Yeah. So we might be talking 0.001%.
Okay. What's the statistical likelihood of being hit by a ransomware attack? It's got to be
80s percentile probably.
I mean it's way up there. You couldn't go below a 50-50 chance really in a lot of cases. But, a lot of people think that their likelihood is like less than 10%, but
you just got lucky so far.
Yeah. Yeah, you may not know what's happening out there.
But yeah, that's a good gauge. Like, if you give me a 50-50 chance, do you think that I'm more, leaning toward the 50-50 side of getting hit or not? And I would definitely say it's definitely leaning toward getting hit.
Mm-hmm.
There's a 51% chance. I'm sure there's somebody out there that has a better figure than what I'm coming up off the top of my head. But our point is you're dealing with a discrepancy of going from 0.001 up to 50%. That's a huge difference in risk.
Yeah. Now, what will happen is that if you're hit, and this is another thing that I know that you love, is if you're hit with ransomware that requires you to report a data breach of over 500 patients, 500 patients or more, then what happens? What does OCR do?
You have a 100% chance of now getting investigated.
Yes, and an investigation is an enforcement action. An audit is a compliance evaluation action. They are two very different things. And everybody's like, I'm going to get an audit. No.
Yeah. Or they're investigating me and therefore they're going to audit me while being investigated.
No. That's not how
it's
it works.
not. Yeah, it's not the same thing. They may be asking for the same information, but it's for different purposes.
Yeah, so let's explain the difference between them.
Okay.
In high tech, there was a section of the law that said that they need to do compliance audits. And we've had exactly two phases. And again, less than 500, it might be less than 250 organizations ever been audited in that program. But the way that program works is they have an audit protocol they follow, and they're looking to see how you are complying with these requirements. And the purpose is to identify areas that the industry needs help in. Very few times in those very few audits that have ever been done, it gets referred from the audit section to the investigation section. Audit says, show me what you got. We recommend you do a few things. You need more work, but we're not super worried. Investigation means you better show me what you're doing.
Mm-hmm.
It means I am looking into this from an enforcement perspective. And that is very different. The enforcement perspective versus the evaluation. And that's what the two big differences are between an audit and an investigation.
Very well said.
Well, I was ready for you to be much more succinct.
That's a fact, Jack.
Blown up, sir. But the biggest issue is people throw around the word audit as if it's the same thing as investigation.
Yeah. Or they'll say, you can get investigated and it'll turn into an audit.
No.
Like, no.
An audit can turn into an investigation.
Right. The other way around. But no, that's not the way it works.
Mm-hmm.
Again, it's one of those points where, let's say coming from the MSP side, if I'm talking to a healthcare client, and let's say it's a doctor, and all this doctor's publications he reads and professional groups he's in, they're having these conversations. Maybe they're listening to the podcast and they're hearing things like your chances of being audited are 0.001%. They're hearing things like this. But then if you're their MSP and you're coming in going, you need to do HIPAA because if you get audited, blah, 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 and it could happen any day. You could be audited. You're going to lose the MSP. You're going to lose all of your trust and credibility because you're wrong.
Yeah.
And you may be talking about an investigation, but you're using the wrong term. You're using the word audit. And so you're just shooting yourself in the foot.
Yeah. And that's where a lot of this gets into. If you read the law, that's where it goes. Start with reading the law. There is a definition of audit in the law. There is a definition of compliance activity and investigations. It even says this is how compliance investigations work. And I can assure you they are different. They are very different. And again, that's why in the boot camp, I mean, we are trying in our boot camp to teach people, and this is not a sales thing. This is how seriously different it is. We actually do our best every class now to bring in an OCR investigator, not some policy person, that explains how investigations work and answers your questions about investigations. And we show you actual questions from investigations and what they've asked to see. It is very different. Very different. So, all of this hoo-ha over audits and fines and penalties, I can tell you the statistical likelihood of here's the likelihood you're going to have a cyber incident that impacts over 500, and that's going to start with an investigation. That investigation, once that starts, if you're not prepared, it can go on for a very long time.
Mm-hmm.
You know, I have a client that came to us when they first got started trying to deal with an investigation. I'm like, really? Now it's not a good time. But it's been 5 years and it's still not settled. So we got another one that came to us this year. It's been a year. They're nowhere near the end of it. That is where your cost goes. The time, the resources, the having to hire me at a higher rate than when you could have hired me. Because now I'm having to throw aside everything and work longer hours. So do not do the FUD, please. Do not do the FUD. The fear, uncertainty, of doubt of audits.
Mm-hmm. It's not going to work well for you.
No.
All right. Number 5. The fines applied to HIPAA cases today are no longer limited to $1.5 million.
Yeah, this one particularly.
Well, we've had more than one episode on this specific topic.
Yeah.
You know, talking about OCR gets a raise or how HIPAA gets a raise or whatever. I don't know how we put it, but and this happened. This has been happening for the longest time. And oftentimes we see people talk about the $50,000. You know, you could be fined up to $50,000 per violation. That's not the same either. All that's changed.
Yeah.
You know, they get all these civil money penalties. They get a raise every year.
Yeah. It's how they're calculated. But again, it's very rare. I think only 2 or 3 times was his actual civil money penalties charged instead of a resolution agreement where they agreed on an amount.
Right. Yeah. And the problem here too is if you go out and you say, I'm going to Google how much the fines are, you're going to find $50,000. You're going to find $1.5 million. You're going to find these numbers and you're going to like, oh, see, I'm right. But, you know, unfortunately, the internet doesn't get rid of all the old information that's not accurate anymore.
Well, and technically, if you look at, we're talking, look at the law. If you look at the law hasn't changed. What it says in the law has not changed.
Right.
The issue is there's another law
that changes the previous law
that says that every year agencies, departments are supposed to evaluate civil money penalties and, you know, they can give them a raise.
Yeah. And they've been getting a raise. And it's not just HIPAA. It's all across the board.
Anything.
Yeah. All these civil money penalties tend to get inflationary adjustments.
Because if the law was written in the 1970s and the penalty was $25,000 today, businesses are struck a check for that.
Yep.
I mean, I wouldn't like it, but I wouldn't freak out about that.
No. Yep. So I think currently it's above 1.7 if you want to know.
Yep. It's getting close to 1.8. Yeah. Somewhere up there.
And the $50,000 limit is either at or pushing $60,000 now.
Oh, and after the MD Anderson ruling, they changed, or prior to the MD Anderson ruling, and then it got reiterated. They've changed how they interpret what their maximums are per violation.
Yeah. they did do that because they made this weird calculation thing
That $25,000 one where
it's like the max is lower than the individual somehow.
Yeah. It's like I can do 50, but this is 25. So they will talk about in general, but if you are throwing those numbers around, you need to know that those are the numbers in the law, but that's not the real world. So, and that
again,
calculation's squirrely.
Yeah. But again, I think this serves to discredit your knowledge if you're going out and you're going to be the subject matter expert and you're talking to clients and you start throwing around these numbers. And if your client is a listener of this podcast, they're going, you don't know what you're talking about because that's changed a long time ago.
Mm-hmm.
And so it just calls your credibility and your true knowledge of the subject into question, and you don't want that.
Well, and even those few times that a civil money penalty actually was applied. Remember when we were like, oh, we get to read how they're actually calculating it. Mm-hmm. Those are rare. You don't know how when they do the vast majority are resolution agreements that do not show you how they got to that amount.
Mm-hmm. Well, I think they do like a lot of us do. They're business owners. We always have this line item, this PETA. And so it depends on your PETA multiplier.
Yeah, there you go. Yeah.
All right.
We don't want you throwing around scary HIPAA fines and then on top of that, not understand how they work.
Yeah.
Okay.
All right. Number 6. I love this one. The number of years that you have been in healthcare IT, or that you've been a nurse or a doctor or a billing person or doctor's spouse, etc., fill in the blank, does not automatically mean you understand HIPAA well enough to address the many complex scenarios that are out there.
Yes.
Man, I always, and it's unfortunate, but I always know, and I rarely use the term always, but I always know when somebody's post online starts with, I'm a healthcare focused MSP, or I've been doing this for X number of years, or I'm a doctor, blah, blah. When it starts with some kind of qualifier.
I've worked in healthcare for 12 years.
Yeah. When it starts with the qualifier, every single time I've ever seen it, all the information is just wrong as it can be. I'm like, the people that actually know what they're talking about don't start with qualifiers in their posts.
No, I'll tell people, like, if you really, look me up, if you want to know, go ahead, look me up. So I can show you, I do know. Let's don't waste time telling me I don't know.
Yeah.
But that's it. No.
But, yeah. And again, if you're getting information from these people, you might be tempted to think, oh, they have all these years in healthcare IT. Mm-hmm. They have to know what they're talking about. Mm-hmm. They're a doctor for 30 years. They have to know what they're talking about. Mm-hmm. Before you do that, do your own research. Do some fact checking, because more often than not, they're probably wrong. But go read the law for yourself.
And when we say do your own research, we want you to start there.
Yeah.
Read the law. And there's plenty of ways to go read the law.
Yeah. Or start with the podcast here and then go read the law.
Yeah. But it's not easy to read. It's not easy to follow. But if you want to be that person that's, absolutely certain, and this is the blah, 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 you got to read the law.
Yeah. Well, unfortunately, in the circles that I run in, I see more misinformation than accurate information.
Yeah. Well, and I think there's several reasons for that. One is bad information being posted out. Like you said, it's being shared by people.
Yeah. It's like bad news. Bad information travels fast.
Well, you see, I don't know if you're still seeing it, hopefully not, where people are like, all you have to do is sign the BAA and you can handle healthcare.
No, I'm still seeing it.
So,
Still seeing it.
okay, those discussions are happening amongst other IT people.
Mm-hmm.
So you're getting that bad information, and that's what I want to hear. So I'm going to stick with the one I want to hear. And, so there's that. There's bad information being put out there by a lot of people that need to reference all of the previous ones we've talked about.
Mm-hmm.
And then the other thing is IT people treat everything like it's some framework or technology debate. Right? You know what I'm talking about.
I know.
They have to debate. It's like, why are you even, how they have time to debate these things? If I ask, what do you think about this? I just want to know what you think about it. I don't want you to tell everybody else they're stupid. I just want to know what you think. I don't need you to say, you could say, I think this because this, and this. That's really all you should be sharing.
Mm-hmm.
Is what you think and why you think that. Not to criticize everybody else that thinks differently from you. But if you want to dig it, the further down a hole you get with technical people, the worse that gets. There's a reason that back in the day, the technical people were all the ones out on the old BBS. You remember those?
Oh, yeah.
And you were flaming people and all, it started then. So they all have to one up each other, and this is the law. This is not one of their technical debates. This is not a Windows versus Linux or
when should you put in a server? How many, what size organization? There, you can argue that all day long.
But that's what they treat HIPAA like, and it's not. It is
Exactly.
not that. So that's the big thing that I think that it's why I can't join you in those discussions.
Dude,
I don't have a patience for it.
Well, there's a lot of them I ignore because sometimes I'll send them to you and you're like, reply this, and this. And I'm like, no, I don't have the time.
I gave you the reply. Is what I always think. Just copy and paste.
Because I know that starts the dialogue because it doesn't stop there.
Yeah.
And it becomes, it's weird because I have to then justify the truth with evidence, whereas they can just throw out the false statements without evidence.
I know. That is the thing that drives me nuts, is that we have to prove ours to prove that you're wrong, but you don't have to prove where you're getting your information.
Yeah.
Just that you're right. So that alone, and by the way, if you show me that you have done your research and it's not anywhere is it mentioning what the law says or particularly related to specific guidance or a resolution agreement, TikTok. That's all I can say. And not like TikTok. It's TikTok. I'll be waiting for you to actually show me your research.
Wow. And if her microphone wasn't in a stand, she would have dropped it just now.
Anyways.
That brings us to the last one. Number 7. HIPAA is not a big monster with no point.
Yes. It's not perfect. Nothing is ever perfect. That's another thing that drives me crazy about people that just complain. Okay, it's not perfect, but you know what? It's better than having no protections at all.
Mm-hmm.
It's like when we turn on security. Do you turn on security by saying, okay, well, first we're going to lock this door, and then if we actually have somebody break into this other door, because we got 5, we're only going to lock this one to see if we need to lock the others? No.
Well, it's like I love the people that make the argument, if there's a good chance I'm going to get hit with ransomware anyway, then why do I pay to have all this protection in place?
Because you want to have business.
Yeah, it's called limiting your risk.
Yes. Again, why put locks on your doors?
Mm-hmm.
Do you leave your car keys in your car because it's a good chance it could get stolen? Do you leave your doors unlocked? do you just give up?
No. I mean, if I live in a high crime neighborhood, I don't say, well, there's a good likelihood that I'm going to get broke into at some point, so why lock the door? I put more locks on the door.
Yeah.
To reduce the chance that the likelihood will actually happen to me.
Yeah, and all the people are like, well, if I'm in a high crime neighborhood, I move. Okay, in this example, what does it take to move? It's called going off the grid. That's what you would do to move.
Yeah, because you're on the internet. There's no other internet to move to.
Yeah. You're either on it or off it.
Yep.
Nothing in between.
Yeah, that's kind of like saying, I want to move to a different planet. Well, good luck with that.
Call up the realtor.
Yeah.
And you better start now with the mortgage company. That's all I'm saying.
Yeah. Yeah. As far as I know, there is no oceanfront property on Mars.
Well, there may be crystals. But we're flying a drone up there. That's just freaking cool. I love that part.
Yeah.
But at any rate, the point that we're making here is it's there for a reason. And that data that we talked about in that chain of custody that is protected health information is valuable. Mm-hmm. If it's valuable to criminals, and more importantly, it's valuable to the individuals.
Yeah, it's about patient care. I know you've never heard that before. If you listen to this podcast, but HIPAA is there to protect the privacy and security of that data that is patient information, and it is to care for your patients, because it is very unpleasant when that information gets used in a way it shouldn't.
Yes. And until you've had to deal with the stories of what's happened to these patients, particularly in the ones where it's just, and that's where the privacy rule comes into play. The privacy rule of HIPAA is overlooked by many, many people. It's like, well, your IT folks will tell you they don't have to worry about the privacy rule. Okay. Got a problem with that. Because what the security rule tells you is that you're doing these things for no other reason if you don't have the privacy rule. The privacy rule tells you what can and cannot be done with the data. The privacy rule tells you what data is protected health information, how to make those decisions. The privacy rule is the basis for the security rule and the breach notification rule and the enforcement.
Right.
So it's without it, there's nothing else.
Mm-hmm.
So if you don't have those protections in place, or let me put it this way, when you do have those protections in place and they're violated, it is pitiful sometimes what happens to people. Their lives are ruined. Their credit could be ruined. The stress causes additional health problems. We're talking a litany of issues. So, plus the fact that HIPAA privacy and security rules been around, this is also a fun one.
This is going to be number 8.
Well, the act, the Health Information Portability and Accountability Act of 1996, Health Insurance Portability, oh God, I've already got myself in a loop because we've been doing too many. But you're quickly going to confirm for me which one I've gotten in my head backwards. So, but the fact that it says it was from 1996, I've had HIPAA experts. I've listened to HIPAA experts say, well, we remember when this all started in 1996 and we had those notice of privacy practices we had to put out. And I'm still waiting for, okay, where's the joke? Because there's got to be a joke here. Because the privacy rule didn't become effective till 2003. It wasn't even published fully as to what was supposed to happen
Yeah, the government has never moved that fast.
No, I mean, we learned that, working on the task group it just, there's too many layers of things that have to take place.
Mm-hmm.
Yeah, we're used to being, we're like a heartbeat away from a decision at any moment that could alter our companies, and we're fine with that. You don't get to do that when there's layers and layers and layers of people. So the HIPAA privacy rule was 2003. The HIPAA security rule became effective 2005. And there's been a few changes to the privacy rule, but nothing else. But how many other privacy and security regulations or rules? PCI DSS is not a regulation. It is an industry standard rule. But it came out. It didn't start until after HIPAA. And we have many, many more that have been implemented and many, many more being discussed. And we know many more are coming. So it can't be that bad. Not a monster.
Nope.
Not an evil thing. It is needed.
No.
It can be perfected, though.
Yeah. And we've mentioned this a number of times as well, which is HIPAA or not, there's going to be something that ends up, capturing the same essence of HIPAA when it comes to protecting privacy and security of data.
Yep.
So even if you're like, I'm not doing HIPAA or HIPAA doesn't apply to me, well, that might be true, might not be true, but there is something. Every single state has breach notification laws. There's something that's going to put you under something that's HIPAA-like. And we're seeing more and more things that are coming that are going to be HIPAA for everybody.
Yeah. Well, and that's why we're encouraging the NIST cybersecurity framework. And, we every couple of months, we might have somebody ask us about NIST cybersecurity framework that's not a HIPAA person. But we're now actively getting companies that are small companies that need to prove to their upstream, because they're business to business. And if you're business to business, you're going to have to start proving that you are doing these things. And I mean, we've had multitudes of discussions and new clients. I had more discussions about NIST cybersecurity framework in a non-HIPAA entity in the last 4 months than I had probably in the last 2 years. So the times they are changing.
I had an MSP that sent me, basically it was a business associate due diligence survey. And they sent it to me and they said, I don't understand any of these things they're asking of me. How do I answer these questions? And it was all about, what is your privacy program, your security program? It was the due diligence stuff. And I replied back to them and I said, if you don't understand any of the things they're asking, then tell them to go somewhere else with their business because you're not going to get anywhere with them. You don't have any of the things in place they're looking for. So don't waste your time, and you're not going to do this in a weekend.
Yeah. Now, if you want to commit to implementing it for, and you might want to consider, since you're getting those questions, doing the implementation.
Yeah. Well, that's what I told them. I said, it's something you can start on, and you could tell them that, you've just started on this type of program or whatever. But if you don't already have it in place and they're looking to do business with you now, then just tell them, I'm sorry, I'm just not there. Just don't have it, because lying your way through it's not a good idea.
No. And there's a lot of people that have kind of been doing that, skating along with saying yes, and they're starting to realize the questions are getting harder to say yes to.
Yeah. Well, not only that, but people are getting smart and they're saying, show me, prove it to me that you've done an assessment.
Can you prove it?
What a just novel concept.
I know.
But yes, they're getting smart enough to say, show it to me. Show me the training that you're doing. Show me the last risk analysis or some type of assessment you have done. Show me the last third-party security assessment you've had done. How many IT companies have third-party security assessments? Because they usually assess their own security.
Yeah, and they leave out all the stuff that, we say we will take what the IT company normally does as a portion of our assessment.
Right.
And that's what you're doing.
It does you no good to have them pull the assessment information on themselves.
Mm-hmm.
You know?
Well, even then, it's not all the things they're supposed to do.
Right.
But anyway, that does bring us perfectly back around to, that you have to understand this for real. And it is not something that at the rate that people throw HIPAA around these days, like they know it, versus the people that actually know it. And those people try to get in there and go, that actually is wrong.
But they get attacked. It's funny how the people that are the most knowledgeable are the ones that get attacked by the ones that are idiots.
Yeah. Well, they are firmly confident in their lack of understanding. They are confident in their lack of understanding. So, we just have to say, I appreciate your level of confidence. However, let's get a little backwards so that you can be confident with the truth.
Yeah. Your desire to be right cannot outweigh your ability to be right.
There you go. There you go. And your wife hopes you heard yourself say that.
Well, I just know that I know that when I'm right, I can open my mouth, and when I'm questioning it at all, just stay silent.
Yeah, I always love that when they ask you, anybody ask you a question and you even process for a second. Oh, you don't know?
Yeah.
That's
Why
it.
does it take you so long?
Are you making something up? No, there's a lot of information up there.
Yeah. It's like, no, I'm trying to think of a way to say it in a way you can understand it.
Okay. We're going to end on that, brother.
All right. That is our show for today, folks. Thanks for listening. Be sure to follow us, share us on your favorite social media site, give us a rating. Don't forget that, and review us. Thank you. Thank you very much. Remember, for Donna and myself, HIPAA's not about compliance. It's about patient care.
You've been listening to the Help Me with HIPAA podcast, hosted by Donna Grindle and David Sims. The show created to help you with HIPAA. For more information or to ask us a question, visit our website at helpmewithhipaa.com. Neither Donna Grindle or David Sims are attorneys, and they do not offer binding legal advice concerning regulatory compliance. The information in this podcast should not be relied upon or construed as legal advice in any way. Consult your attorney for legal advice concerning compliance with HIPAA regulations.